Welcome to Chapter 6 of the Wealth Management Essentials course. In this chapter, we'll be going over legal aspects of family dynamics. So in the chapter, there are 5 different learning objectives. We have some discussion around family-related issues, fundamental aspects of family law, domestic contracts, property issues on relationship breakdown, and the impact of divorce on a client's financial plan. So the first topic we'll touch on is family-related issues. So one of the issues is gifting money or assets to family. This can be an issue. There are certain tax rules around that, which we will touch on. But the main impact of it is that technically when you do give an asset to someone else, if it is someone in your family or not, you are no longer the owner of that asset. So you are giving them ownership. They can do whatever they want with it. Funding education for children or grandchildren, that can be sometimes an issue. Maybe you look at setting up an RESP and things like that. Financial support of a minor or adult children, future leadership and direction of the family business is another issue, long-term care of a spouse or aging parents, elder abuse, leaving estate assets to charity, and of course a divorce. And divorce sets up some potential problems regarding privacy, conflicts of interest, and the requirement to act in the best interest of a client. So as an advisor, it can be difficult when working with a couple that is going through divorce. It is easy to become emotionally involved. After all, you have developed friendships and relationships with both clients, and it can be difficult to remain impartial when dealing with it. So when advising clients in the process of separation, you must understand the general dynamics of separation and its financial and emotional impact on families. You must try to avoid conflicts of interest and advise your clients to retain independent legal advice immediately upon separation. You can provide invaluable assistance by working cooperatively with a separated spouse and their legal advisor to prepare a forward-looking financial plan, taking into account the financial and tax-related consequences of the relationship breakdown. Now, looking at some fundamental aspects of family law, you should always recommend obtaining legal advice from a lawyer that practices family law if a client is considering separation, just because family law is nuanced, multifaceted, and constantly evolving. But just some basics about family law to understand. So with marriage, both parties must have free and enlightened consent to be the spouse of each other. So that's required if you are going to become married to someone. Both parties must also be at least 16 years old, and no person may contract a new marriage until every previous marriage has been dissolved. There's also a slight difference between marriage and common law relationship. So common law relationship is defined as 2 people who live together in a conjugal relationship. Unmarried spouses in Ontario are not entitled to seek an equalization of net family property. So that is one key difference between the two. In most other provinces, that isn't the case, and common law spouses are still entitled for equalization. So now just talking a bit about divorce. So divorce is the final legal ending of a marriage by court order. The ground for granting a divorce is breakdown of marriage, which is established if spouses have lived separate and apart for at least 1 year. But if there is finding of adultery or mental or physical cruelty by the court, then the divorce can be granted immediately. So if, for example, your spouse is basically threatening to kidnap the kids or make it so you won't have custody or ever see the kids again, that is considered mental cruelty, and the divorce can be granted immediately. Also with divorce, division of assets and resolution to various issues is usually resolved in the separation agreement. So during the divorce process, a client obviously has a range of emotions, and it is important to be mindful of your client's emotional state when dealing with them. Another touchy subject with divorce is the custody and access to children. So this is usually outlined in the separation agreement. Sometimes there are sole custody orders. They are increasingly rare, but they are issued in cases where a primary parent has full care and control of a child. The legal responsibility for decision-making rests with the custodial parent. However, the other parent still does retain the right to make inquiries and to be given information as to their health, education, and welfare of the child. Usually, parents will have joint custody orders, which just refers to a parenting agreement in which the parties share major decision making relating to the child after separation or divorce. Shared parenting is the term generally applied to parents that share at least 40% of the time with the children. There's also the best interests of the child. So the Divorce Act stipulates that a child should have as much contact with each parent as is consistent with the best interests of the child, commonly referred to as the maximum contact principle. So in making decisions about custody access, courts take into consideration the willingness of the person seeking custody to facilitate the child's access to the non-custodial parent. Now, there are also some different domestic contracts that you should be aware of. One is the cohabitation agreement. So this is a contract that two unmarried people that cohabit or intend to cohabit may create. It deals with the ownership or division of property and spousal support obligations. If the parties marry each other, the agreement becomes a marriage contract, but should usually be written to include issues that would only arise upon marriage. And then a marriage contract, that's an agreement between two parties who are married or plan on getting married. It addresses ownership and division of assets and spousal obligations, so same as the cohabitation agreement, but they cannot address the right to child custody. Provisions in the contract that attempt to limit a spouse's right regarding possession, transfer, and encumbrance of the matrimonial home is unenforceable. And then you also have the separation agreement, which usually resolves all the issues arising from a relationship breakdown, such as custody and access to the children, child support, health benefits, security for support, equalization of net family property, and division of assets, etc. So it is important to know those three different types of contracts. Now, there can also be a situation that arises where one of the clients challenges a domestic contract. So a domestic contract can be challenged under the three different conditions. First one being duress. So it could be voided if one party was induced to sign by violence, threats of violence, or other undue influence from the other party. The party who claims to have been under duress must prove it. There's also what's called an unconscionable transaction, so sometimes referred to as an unfair advantage. This is when the situation would shock the conscience of the court. It does not mean merely a minor unfairness, but a situation that cries out to be altered. And then there's the alternative dispute resolution, which is the resolution of family law that disputes through means other than traditional litigation. It may include negotiation, collaborative family law, mediation, or arbitration, and it's meant to help clients achieve a solution in a more cost-effective and cooperative manner. Now, you do have various property issues on relationship breakdown. So property rights, they are governed by provincial legislation. So legislation regarding the treatment of property on relationship breakdown, it does vary between provinces. In fact, in Newfoundland, commercial property is excluded from the sharing regime, and valuation dates and methods also vary between provinces. But the death of the spouse, that's another situation, so it is considered a breakdown of marriage as well. If the net family property of the deceased spouse exceeds the family property of the surviving spouse, the surviving spouse is entitled to seek an equalization of net family property. Now, when a spouse dies with a will, the surviving spouse may elect to take under the will or seek an equalization payment. So if the spouse dies and they aren't going to be given any of the assets, basically the spouse does have a right to get some equity from that. Now, there are two types of assets that are excluded from net family property. So that would be property other than a matrimonial home that was acquired by a spouse by gift or inheritance from a third person after the date of marriage. So say both your parents die and they pass you down a cottage. Well, that is an inheritance from your parents, and it was given after the date of marriage. Well, that is excluded from net family property because it was given to you. And property that the spouses have agreed by domestic contract is not to be included in the spouse's net family property is the other thing that can be excluded. It's also important to understand the impact of divorce on a client's financial plan. So it will impact a lot of different aspects. First, we'll look at the tax planning issues. So this includes the loss of income splitting opportunities and the loss of income tax deductions and credits. So that can be a pretty big deal. Say a family needed, let's just say $80,000 per year as household income just to cover expenses. Well, when a family separates, or spouses separate, it's not like that their expenses just are cut in half. Maybe they do have a bit less expenses. Maybe it drops from 80 to 60 or 70,000, but it still is fairly high. And now that one person must make all of that income, so they're going to be paying a higher average tax rate. So that can be an issue. Clients should also understand the non-deductible and non-taxable nature of child support payments. That's another consideration. And spousal support is deductible by the payer and taxable to the recipient. Now, when it comes to retirement planning, resolution of property issues as well as ongoing support obligations will affect the plan, and equalization payment may be satisfied by a lump sum transfer out of a spouse's pension, RSP, or the sale or transfer of a home. Risk management, this includes changing RSP, pension, and life insurance beneficiary designations. You may change the amount of life insurance coverage. Sometimes a spouse is obligated to pay child support, and this sometimes requires to have a certain amount of life insurance coverage just in case the spouse dies and they can't continue to make that child support payment. So sometimes life insurance is required. There are some estate considerations. So divorcing clients should update their wills, including their wishes regarding power of attorney. Divorce will also revoke the provisions of a will respecting that spouse. However, separation does not. So that is important to know. And finally, the cost of divorce. So costs include legal fees, expert fees, the increased cost of maintaining two households, effect of property resolution, etc. And so that is everything, all the main topics in Chapter 6. So if you do go through the learning objectives, you should be able to have some answer to each of the objectives. I really hope you found this chapter helpful, and I'll see you in the next chapter.